Hi Emma, this stream is now live.
Thank you. Good evening and welcome to this meeting of the Planning Committee on Tuesday the 9th of March 2021. Before we commence the proceedings, I can confirm the Council has adopted some basic etiquette rules for its meetings, and these are as follows. Please only speak when the Chairman invites you to do so. Members, please let the Chairman know that you wish to speak through the chat function. The Chairman will introduce speakers in the order at which the request to speak has been made, unless there is a point of order at which we will give way. Please minimise all distractions while you are in the meeting. Members, you are asked to mute your microphone when you're not speaking and to consider turning off your video feed if you have interference to your connection to the meeting. Please bear in mind that there may be a lag between speaking and other attendants hearing you. Presentations for this evening will be shared on the screen by officers. If you have any issues with viewing these presentations, please indicate via the chat function. Members, when referring to officers' report, it would help us if you can quote the relevant page and paragraph number. Members, there is no private business for tonight's meeting. However, if it is necessary to move into private session, it is your responsibility to make sure that your venue and connection is private. If you lose connection at all, please rejoin the meeting immediately and I will readmit you to the meeting. Please use the chat function for the purpose prescribed for requesting to speak or for point of order. The chat function is subject to the access to information regimes of FOI, EIR. It is also subject to data protection, rules of defamation and the Council's Code of Conduct. To assist with managing the chat function, the agenda items will be placed in chat function to act as markers. The Planning Committee consists of the following members. The Chairman is Councillor Wendy Scattergood. The Vice Chairman is Councillor Iona Parker. The remainder of the committee are Councillor James Abbott, Kevin Bowers, Tom Cunningham, Patrick Horner, Hilton Johnson, David Mann, Andy Mundy, Frankie Ritchie, Gabrielle Spray, Nick Unsworth and Justin Wrench. For this evening, we have no apologies from members. We have officers in attendance, and these include Chris Paggi, Planning Development Manager, Matthew Wild, Senior Planner, Lisa Page, Senior Planner, Carol Wallace, Senior Planner. We have one other planner who is observing tonight's meeting but is not participating. We have one Governance Officer, Alison Webb, who is clerk in the meeting, and if we lose connectivity to any of our registered speakers, Alison will read their statement on their behalf. My name is Emma Wisby. I'm the meeting facilitator. Councillors are distinguished by a prefix of CLLR before their name, officers have a prefix of officers, and registered public speakers have a prefix of PQT. I can confirm the meeting is quorate and the meeting can proceed. I now hand over to Chairman, Councillor Wendy Scattergood. Thank you.
Thank you, Emma. Emma, did you wish to check Councillor Bowers' connection? He has just signed in.
Yes, please, Chairman.
Before we start. Thank you.
Thank you, Chairman. Councillor Bowers, can we just test your connection to the meeting, please?
Hi, Emma, and apologies for being a little bit late. I was having an issue with my connection, but I seem to be fine now. If you can hear me, that is.
We can. We've got a good connection to you. Thank you very much, Councillor Bowers. Thank you, Chairman.
Thank you. Thank you very much, Emma. Thank you very much. And good evening, members of the public who are watching us on YouTube, members of the committee, all those people speaking, and also our planning officers. I am Councillor Wendy Scattergood, Chairman of the meeting. I think after a year, we all know the rules, so I'm not going to go through those again. Item 1, apologies for absence. We have none as everyone is present. That's excellent. Item 2, declarations of interest. Does any member wish to declare the existence and nature of any disclosable pecuniary interest, other pecuniary interest or non-pecuniary interest relating to items on the agenda having regard to the Code of Conduct for members? I have no one indicating on the chat function that they wish to speak, so I will move on to item 3. Item 3, I have the minutes of the 2nd of March. I will need, if you are approving these minutes, I will need a mover and a seconder, and I will take silence as approval.
Great record, Chair.
Thank you. Does we find a seconder, please? Thank you for Councillor Ritchie. The minutes have been moved by Councillor Mann, seconded by Councillor Ritchie, and I will take silence as your approval of these minutes. Thank you, members. Item 4, public question time. We have no general public questions this evening. All public questions and statements are made prior to each application. We now come on to item 5, planning applications. Members, we do have one application on block in part B, which we could on block. This is application number 20-01516HH, 23 Greenfields, Gosfield. This application comes before us because the parish council has objected but the application meets our planning policy. Does anyone wish to move that we unblock this application?
I will, Chair.
Thank you, Councillor Mann. Does it find a seconder?
Second it, Madam Chairman.
Thank you. I will take silence as your approval for unblocking this item. Thank you, members. Members, that application has been granted. Thank you. We come back to the applications under Part A. And the first application in Part A is application number 20-01465 full, land to the rear of Heathers and Candletree, the Green, Hatfield, Peveril. The application can be found on pages 6 to 38, and I have 3 speakers on this application. I'll wait for the speakers to be admitted to the meeting, and then I will take them in the order I have them.
Chairman, the registered speakers are currently being admitted. We currently have Mr. Wilkinson, we currently have Mr. Dowell, and we are just waiting for Councillor Renal to join the meeting.
Right, shall I wait for Councillor Renaud to wait?
He's now in the meeting. Thank you, Chairman.
Thank you, members. As I said, we have 3 speakers on this application, and the first person making a presentation is Mr. Kevin Dale, but he is speaking on behalf of Mr. Mark East, who is an objector. Mr. Dale, would you like to make Mr. East's statement for us, please? You have 3 minutes. Thank you.
Yeah, speaking on behalf of Mr. East and the resident volunteers behind our NDP, I will just highlight the key points of his statement that you've got before you. The statutory documents are the 1990 Town and Country Planning Act and the 2011 Localism Act. The NPPF is just an advisory framework. It does not override the law. The starting point for the decision are the adopted plans and policies, i.e. Section 1 of the local plan and our NDP. The 2021 Fitch Green Court appeal judgment has reinforced paragraph 11 does not give automatic position. Existing policies do carry weight. 11A indicates plans should meet the needs of their area. Our MADE NDP clarifies those needs. Numbers in BDC's ward profiles clearly show Hatfield Peveril market housing will deliver 7 times the given affordable housing need. Paragraph 59 has been quoted, but the quote omits to recount that boosting housing supply should be where it is needed. A February 21 appeal nearby on Crabs Hill, outside our settlement boundary, was dismissed. In that, the inspector noted Hatfield Peveril has only moderate facilities. We rebuff any suggestion that our development boundary has not been reviewed. It was reviewed by the LPA during the NDP, ratified at formal examination of that NDP, and endorsed by the residents' referendum. The examiner of the NDP added herself, quote, new development will only be permitted where it can be demonstrated that there is sufficient and appropriate education capacity. Officers' report here does not effectively address this issue. Essex Education have not made a statement. Essex County Council's 2019 10-year plan flags that we have no capacity. Residents are clear that with some 500 new houses currently underway, our school and doctors are at capacity. Our parish council has written outlining our current housing supply is 20 to 60% more than the independent consultants' assessments of OAHN. Recent quoted court judgments have clarified that cumulative impact of developments must be considered. Our community have fully participated to help devise plans via the examined and made NDP, a plan which clearly includes the development boundary. The Localism Act requires our LPA to recognise this. So given this statement, I urge members to refuse this application.
Thank you very much, Mr. Dale, for making your statement on behalf of Mr. East. I now come to Councillor Mike Renaud, who is speaking on behalf of Hatfield Peveril Parish Council. Mr. Renaud, thank you. You have 3 minutes.
Thank you. Good evening, Madam Chair and members. Thank you for the opportunity to speak on this application. I wish to make the following comment further to the previous submissions of the Parish Council. With regard to paragraph 59 of the NPPF, the Parish Council are of the opinion that the parish has provided sufficient land to meet its objectively assessed need, going beyond Barton Willmore's comprehensive review, Hatfield Peveril Housing Requirements Study, Open House, Barton Willmore, 14th of August 2015. While the adopted neighbourhood plan does not specifically allocate a site, it's a fact that the sites with recent planning permission meet the objectively assessed need. The Parish Council has no say at examination on the removal of the ALA Policy H06 as a proposed allocation in the draft plan, which meets the parish's identified need for housing and was within the development boundary. An indicative housing number was provided during development of the neighbourhood plan, and due consideration was given to the development boundary assessed against that housing need. Furthermore, Braintree Council and the neighbourhood plan examiner were privy to the development boundary and did not challenge it. While the boundary is in need of updating to reflect Glen Eagles, Stonepath, Berry Farm and rear of the Wheatsheaf developments, this will be addressed in a review of the neighbourhood plan to be carried out in due course, and also by Braintree Council as a component of the Part 2 local plan. A recent inspector's report on the site on the western side of the village, land adjacent to Oakley Lodge, Crabs Hill, 1902-233 full on the 16th of February 2021, specifically supported the development boundary as a key point in refusing the application as an unjustified intrusion into the countryside. The Parish Council do not agree that a lack of 5-year supply of housing is adequate justification for considering an area sustainable. Hatfield Peveril has already supplied land for such provision considerably above identified need and what is objectively considered to be capable of supporting. Allowing further development runs contrary to the stated aims of the Part 1 local plan recently adopted by overstretching existing infrastructure. The Parish Council would draw your attention to the recent Court of Appeal judgment on the NPPF Title 2 balance, which may have relevance to this application. Gladman Developments Limited, SSH CLG and Corby BC at Uttleford BC 2021, EWCA Civ 104, 3rd of February 2021. Parish Council asks that the recommendation to approve this application is rejected. Thank you for your time this evening.
Thank you very much for making a statement, Mr. Renaud. And now I invite Mr. Jack Wilkinson from Wilkinson Planning. He is making a statement on behalf of the applicant. Mr. Wilkinson, please, and you have 3 minutes.
Thank you, Madam Chair. Good evening, members of the public. I'm Jack Wilkinson, the planning consultant acting for and on behalf of the applicant this evening. The application before you is for the erection of 7 sustainable dwellings in a sustainable location without any demonstrable harms, which I will now go on to discuss. The applicant has shown integrity and tact from the start through thorough assessment of the site, which included close dialogue with key consultees. This is evidenced by the fact that no technical consultees have objected to this application. There are no professional objections from the local highways authority, ecologist, archaeologist, or environmental health officer, for example. The application has attracted a handful of unevidenced objections from neighbours and the Parish Council. This is unfortunate, but we can't please everyone, and I don't think the planning system ever will. Whilst it is regrettable that these objections have been received, no objections were received whatsoever from professional consultees. This is important. This application therefore requires a rational and logical planning-based decision, much like your officer's recommendation. The committee report is spot on. It captures all of the material planning considerations engaged in the determination of this proposal, drawing a sound conclusion. In summary, the proposal adjoins the defined settlement boundary with no objections from technical.
The Chairman, to take your presentation back to in summary, please.
Of course. Can you hear me now still?
We can, thank you.
Perfect. So in summary, apologies. The proposal adjoins the defined settlement boundary. There are no objections from any technical consultees. The access capabilities surpass the minimum requirements, and the proposal is in a sought-after accessible location for housing. The design will provide refreshing uplift to the locality that will be NDSS compliant throughout. There will be social benefits for the pub and community with spending power locally, which will assist local businesses. There's also a landscaping condition as well, which will offset any marginal tree loss. This is a deliverable scheme which would make a modest yet positive contribution to the council's land supply. Members, you may recall that your officers withdrew this application from the January agenda with a view to obtaining legal advice from legal counsel in respect of the Hatfield Peveril Neighbourhood Plan. The application presented to you this evening has been thoroughly stress tested against the neighbourhood plan, and legal counsel have supported your officer's report. You are able to make a procedurally sound decision this evening in full view of all material planning considerations, which again your officers have reliably reported. Certainly the benefits of this scheme far outweigh the harms, if any. There is nothing about this scheme which would warrant refusal of planning permission. Indeed, there are plenty of reasons to approve it. Moving forward, I encourage you to support this sustainable proposal and grant planning permission in the terms set out in your officer's report. Thank you for your time.
Chairman, your microphone is switched off. Apologies.
Thank you, Mr. Wilkinson, for your statement, and I would like to thank once again Mr. Dale, Councillor Renault, and Mr. Wilkinson, and ask you to, if you'd like to remain and listen to the discussions. The presentation is now going to be made, and it's going to be made by Matthew Wild. Matthew, could you make the presentation, please?
Good evening, Madam Chairman. Good evening,
evening.
members. Bear with me 1 second while I share my screen. Okay, can you see my slides? Yeah, okay.
Thank you.
So the application before us this evening is for the erection of 7 two-storey houses with 17 parking spaces, and it's land to the rear of Heathers and Candletree in Hatfield Peveril. Now, just to bring members, just to show members really the appeal site, you'll have seen in the report that there is a copy of the appeal decision, but just to show you the plan form of that, you can see that it is also for 7 dwellings, and it arcs around a reconfigured car park for the Wheatsheaf public house. Just to sort of sum up that decision really, officers raised concerns at the time with regards to character, impacts on the public house in terms of viability, impacts on the amenity of future occupiers, and the loss of the caravan site, which was there historically. The inspector disagreed with the issues and allowed the appeal. I'll come back to some of these points in more detail later in the presentation. But yeah, just so you can see the form really. And it should be noted as well that this decision predated the neighbourhood plan adoption. Okay, so this is the red line site plan. So I did ask that during the application process that the red line amended so that it followed the line of the existing access road on the properties there, just to show that it would be able to take access from Oldham Road. And then you can see the red line here is actually where the dwellings would be in the gardens of what is currently Heathers and Candletree. The development would also be adjacent to the properties in Old School Court over here, and then it's got the sort of wider countryside beyond at the rear. Okay, so a bit of more context for you. When this was taken, you can see that the properties that were allowed on appeal were under construction, and you can also see that the gardens of the 2 properties. I've also included a wider plan just to sort of better show the pattern and grain of development. I think with the appeal that was allowed, it does sort of change the character of this side of Oldham Road a little bit, so that when we look at the application on this part of the site, we have to obviously bear in mind this is here, and this has had an implication on the consideration process. Okay, so the 7 proposed dwellings. So it's a continuation of the existing development, which is shaded in grey here. So you can see the plan form of that property there, which has been built. And you can see that there's two in terms of continuation, and then it turns the head, if you like, and comes back towards the village with the remaining properties. So because of this infilling, the change in settlement pattern, as I just discussed, and the consideration set out by the inspector when he was considering the appeal, in this case, officers have concluded that the 7 additional houses here would be seen in the context of the existing settlement and not lead to a detrimental impact on the character and appearance of the area. In terms of neighbour impact, one of the things that we did ask that was changed as part of the application process was the distance between the proposed dwellings here and the properties at the rear of an old school court here. So what's basically happened is that now there's a 25-metre back-to-back distance, which would accord with the Essex Design Guide in terms of the normal standard. So because of this distance, we're satisfied that the amenity of these occupiers here would not be detrimentally affected by the future occupiers of these proposals if they are approved. In terms of impacts from the public house and the car park in terms of noise, again, it was something that we on this site tried to set out was an issue, but the inspector was happy with the mitigation measures that were set out, which include an acoustic fence, which I'll show you, which is now in place, and also ventilation measures, and I'll show you that as well, because I've got an example of that. So yeah, with those measures in place, which is what is proposed, officers are comfortable that the future occupiers of these properties would also be okay in terms of their amenity. In terms of highways and parking, Essex highways are satisfied that the access would be able to accommodate the additional traffic, and the parking is in accordance with the parking standards. So just briefly then, just taking you through some of the house types. So this is house type 1, which is a 4-bedroom property. The design is fairly contemporary. It does actually represent a continuation of the existing development, which we'll see in the site photos. This is the second house type, which is a 3-bed unit, of which has 5 of these. And then you've got house type 3, which is just one of these, but it's the corner turning unit. So it's basically the same as house type 2, but it has that additional gable and additional fenestration to turn the corner. So that is this unit up here, just for members' awareness. Okay, so just quickly as well, just showing you the street scene. So the 2 properties, the 2 4-bedroom properties, and then you turn back and you can see the 5 of the other properties and the backs of, and then you can see that corner turning unit there, as I've said. So it effectively addresses both frontages. Okay, just to go through some of the site photos then. So mixtures of times. So I went out to the site twice, one in October and the other one just before Christmas. So if we're looking at the site access here, and the Wheatsheaf pub is on my left. So this is looking at the appeal site that was allowed. Obviously, you can see it's fairly far advanced at this stage in October. The access road would be the same as I've said for both. So I've actually got a picture here from the first floor of one of the units. I was fortunate enough to go out and have a look at the development, just obviously for future learning, see how it came to be, because we did negotiate changes on the allowed appeal site, even though we did end up refusing it. So you can see the acoustic fence that I was talking about, and you can see the reconfigured pub car park and the play space, and then you've got Malden Road down here. So just a couple of other shots of the dwellings. So yeah, just showing you a couple of examples really of the sort of house types that we are expecting to see on the other site. So that's one of the bigger houses, which are then going to be continued over here, which is where the site is. So it would effectively go through here. And again, just looking from the pub car park, the site's on my left, and then you've got the houses in front of me here. I did say I'd talk about the ventilation. So sort of the layman's explanation, which is what I understood, is that effectively there's a panel on the side of the house which opens if the property inside reaches a certain temperature, and that will then let air flow in to that unit without them having to actually open the window. So it obviously reduces the noise because it's on the side, but also allows them to have air, certainly in the summer months when people might be outside using the pub garden, etc. Okay, so just some more pictures then. So looking from the actual development site itself, so or the start of it anyway. So that's Candletree, and that's Heathers in terms of the road frontage. Okay, so I'm in the Garden of Heathers at the moment, looking northwards, looking down the garden anyway to where you can see the tennis court and the back there. You can see the sort of back of those properties on Old School Court that I talked about earlier. And then I've sort of moved further up the garden to look back. You can see Heathers and Candletree over here. And I've moved a bit further down the garden again. So you can see the tennis court, and you can see the boundary between the two properties, which obviously would be removed as part of the development. And then just a photo looking across to where the appeal site is, and obviously the back garden of Candletree. This photo is taken actually in October, so you can see the access road wasn't made at that particular point. So you can see so this is Candletree now, Candletree's garden. So looking down Candletree's garden, and again a picture that's a bit closer to the back there, and then just looking back up the garden really. Obviously there is some vegetation on the site, but it's all domestic in scale. I think we've put conditions on about tree protection in our report. So what we'll try and do is save the best trees where we can, and if there is going to be some loss of the trees, we'll make sure that they are adequately replaced, through a suitable landscaping condition. Okay, just summing up then. One thing I do want to raise actually before I sum up is that I've noticed on page 22 of the officer's report of the agenda that there is a line missing in the habitat regulations assessment text. So I'll just read that out just for the avoidance of doubt, just so we're all aware. So it says management measures for the Blackwater Estuary, SPA and Ramsar site. And the missing text is £125.58 per dwelling in accordance with section 111 of the 1972 Local Government Act. The developer has agreed to pay this contribution £879.06 up front prior to any decision on the application, blah, blah, blah. So just to confirm that HRA has been paid and to the correct amount for this development. Okay, coming back to my summary. So the proposal would conflict with policies RP2 of the adopted local plan, policy CS5 of the core strategy, and policy LPP1 of the draft section 2 plan, owing to the location of the dwellings outside of defined settlement limits. These policies, however, are out of date by virtue of their age and carry limited weight. As set out in the report, officers haven't found a conflict with the neighbourhood plan in this particular case. So officers are of the view that the tilted balance applies. So obviously have to be mindful of that in decision making. The site is in an accessible location. It has access to the train station, and it does have, it's a key service village, so it does have services and facilities available in the village. In terms of the other points, the overall character and landscape impacts of the development would not be detrimental. The scheme would successfully integrate with the proposed development in officers' opinion. It would provide good quality amenity for future occupiers. The gardens would comply with the standard, and equally the internal accommodation would meet the nationally described space standards. And similarly, the additional protection measures with the acoustic fence and mechanical ventilation, again, will protect the amenity of future occupiers. The development wouldn't cause any detrimental impacts on neighbouring properties. There will be some loss of trees, as I've said. However, any losses would not be significant and will be able to be mitigated on the site. There will be jobs during construction and the contribution towards the vitality of the village. And then 7 dwellings towards the housing supply, which, as we all know, is below 5 years at this time. And then, there is no required contributions towards open space or affordable housing in accordance with the case law in this particular case, for reasons set out in the report. HRA has been paid, as I've just said. So overall, the officers are of the view that the benefits outweigh the harms in the tilted balance, and therefore approval is recommended. Just picking up a couple of points at public question time, just before I finish. I think it should be noted that the recommendation is not to grant permission because the tilted balance applies. Not to grant permission automatically because the tilted balance applies. Instead, it's a reasoned recommendation, taking into account all matters, including that central part of national policy has been set out in the report. The NPPF primarily requires considerations of housing needs at district level, so we can't discriminate between different areas. We can only look at the considerations within each area when each application is submitted. The proposals are not contrary to the neighbourhood plan, as I've said. And in terms of education provision, I spoke to colleagues at Essex County Council, and I've also checked their developer design guide, or if it's the infrastructure guide, and yes, there is no requirement for an education contribution. Their threshold is 20 or more dwellings, and I understand this is because they can only secure so many contributions from development for certain projects. And obviously what they want to do is make sure that they secure money on the bigger developments, which will give the bigger return, rather than on smaller developments, which will give less return. So I hope that is clear for members' benefit. And that is the end of my presentation. Thank you for listening. Any questions, please let me know.
Thank you very much, Matthew. Thank you for a very detailed presentation. I guess I do have speakers. The first person wishes to speak is Councillor Mann. Councillor Mann, please.
Thank you, Madam Chairman. A question to start off. What weight should we give to the inspector's comments on the allowed appeal on the adjoining site? For example, about the lack of harms.
Thank you, Councillor Mann. So the inspector's deliberations on those matters are highly material to determination of this application. We have to take that into account. I think we'd be seen as very unreasonable if we didn't take that into account. I hope that answers your question.
Thank you, Matthew. Councillor Mann, do you wish to, anything else you wish to say? Councillor Mann?
Thank you. Yes, I think that accords with my interpretation of the situation. That the fact that we've got a very strong appeal decision on an immediately adjoining site, I think it adds quite a significant weight, and I'm just thinking forward to a possible appeal, another appeal situation where we would simply get that finding, I think, fed back to us. So I think it's something that we have got to consider very carefully.
Thank you, Councillor Mann. Councillor Abbott.
Thank you, Madam Chairman. Yes, I agree. We have no choice but to take account of what the inspector said. But the inspector said, and it's in the report, that the adjacent site was on previously developed land. This is on 2 plots of land which are largely large gardens, apart from the tennis court, backing onto the countryside. So I think there's a material difference there. Secondly, whilst I agree with officers about the need to look at housing numbers on a district-wide basis, which is unfortunate for Haver Pebble because, like many other villages, it's taken a huge amount of development due to the, well, you know what my views are on the local plan process. I won't rehearse them again. We can't necessarily take that into account on this site. However, the point I want to make is that not only is this an unallocated site, it's unallocated in section 2. And we now have, because section 1 has been adopted, some weight we can give to section 2. It's in all of the reports before us tonight. So this is an unallocated site, and it's contrary now to a part of the local plan which we can now give weight to, which is different again to what the inspector has looked at. So in my mind, there's 2 material differences from where the inspector was making the decision and where we're making the decision tonight. The further point beyond that is, if we carry on with this process where we don't have a fully adopted plan part 1 and 2, we could be doing this for another year or more, of simply tacking on sites in the countryside that are outside development boundaries because there might be a precedent because somewhere else in that road or an adjacent site has been given planning permission on a repeal, or we have. And where does that process end? Development boundaries are there for a reason. And because of those policy reasons, I'm not going to support this tonight. The other point I wanted to make is one I've raised many times before. In the report, it states that the trees on the site are of low value. Why do we keep getting reports saying the trees are of low value when we could all see for ourselves there were live trees on that site? The officer had given us no objective assessment of how many trees will be lost. If you compare the aerial view of those sites to the site layout of the house, it's quite clear there'll be significant tree loss, particularly within the site. So can I ask the officers, where's the objective assessment of how many trees would be lost? And also, why is there no landscaping plan before us, given that this is a full application? Why wasn't that requested at the validation stage? Thank you, Madam Chairman.
Thank you, Councillor Abbott. Do you wish to come back on that before we move on? Matthew, please.
Yeah, of course. Thank you. Thank you, Councillor Abbott. Yes, thank you. So the landscaping plan, often we would actually condition the details of that, certainly for a full. I think when you have the outline and reserve matters application, then we would get the landscaping details as part of the reserve matters, because it's a condition on the outline. I think where we've got a full application and we're content with the proposal in the whole, we wouldn't necessarily ask for those landscaping details up front to start with. I think it's something that can be secured via condition if development gets approved, and obviously we get our landscaping team to look at that and make sure that's appropriate. In terms of the assessing the trees on the site, we would usually have an arboricultural assessment submitted with the application. This hasn't been provided at this particular for this particular application, but we are asking for one through condition. And I think, given that the trees on the site are, in private gardens, they're of a domestic scale, and there was an ecology report done which did categorise the trees. I think officers are content in this case that we can deal with that through a condition, and make sure that any, protect any trees that are of good value could be retained, as far as possible. I mean, the trees could be removed tomorrow, potentially, or certainly within the appropriate months without any form of consent. So I think us securing a tree protection plan to secure those better trees where we can is an appropriate way, and we can do that through condition in this case. But I think that answers your question, but please ask again if not. Thank you.
Thank you, Matthew.
Madam Chair, could I come back, because it doesn't answer my question actually. My question really is why. So officers may be content, and I accept the officers may be content, but we are the decision makers. We're the planning committee, and we're here to decide whether this application is acceptable or not. And I don't understand, given this is a full application, why we don't have before us tonight an objective assessment of the tree loss and also what the replacements are going to be. I think that is a pretty basic requirement actually, and I'd be very interested to know going forward if that is the view that we're not entitled to see that. I think we are. The comment about trees being low value and of domestic scale, I'm not really sure where we are with this. I mean, the low value thing keeps coming up application after application, and I don't believe they are just visually, but we don't have a report anyway to say otherwise. But domestic scale trees, well, in terms of biodiversity, I don't know what that means. I mean, trees, pretty much all trees have some biodiversity and landscape benefit. I mean, it varies obviously, but this site will clearly result in significant loss of trees. And I'm very concerned, as well as the policy reasons I said, as to why we don't have those details and replacement details in front of us. And I'd like officers to consider, please, going forward on future sites that we do have those details. Thank you.
Thank you, Councillor Abbott. Councillor Unsworth.
Thank you, Madam Chairman. Just to pick up on a couple of points that the developer made. He said it's a sustainable development, but I don't see any nod to that in the conditions laid out in terms of sustainable water recovery, grey water recovery, that sort of thing. So just ask a little bit about that. And this really concerns me. We had a case on this fairly recently where somebody was speculatively, just opportunistically developing their garden. And that's what this looks like to me, just developing the garden and tacking it onto a development as a result of an opportunity. So, we're losing green space quite significantly. I wonder what gardens are left on the two houses that have taken this opportunity to develop their land. I wonder are there any conditions on the land that stop those gardens being developed? Whose responsibility is that? I don't know. The question is whose responsibility is that there? And it seems to just significantly reduce the gardens. And like Councillor, I echo Councillor Abbott's response here. I don't like this at all. This is just speculative development of gardens tacked onto a development, and I really don't like this at all. So I'd just like to know a bit more about the sustainable part of the development that's referred to, and if there are any conditions on gardens that prevent any form of development there that we might not know about, or whose responsibility that is. Thank you.
Thank you, Councillor Unsworth. Matthew, I think you better come back again before we move on, please.
Thank you, Councillor Unsworth. So, yeah, I mean, I think I've got your points, but if I miss one, please let me know. I mean, we in terms of the application, it's not an adopted allocated site in the Part 2 plan, but because it's only 7 units, it wouldn't be allocated anyway, because that only accounts for units of 10 or more. In terms of the gardens themselves, there's nothing preventing them submitting an application to develop those gardens. I think they're quite fortunate in the sense that those 7 dwellings have been approved on appeal adjacent to it, because otherwise they wouldn't really be able to get an access to that. So there is an access there to these gardens, and obviously now as a committee it's for members to decide whether they think the scale and form of the development is appropriate. Whether you like it or not, obviously we have to assess the application based on planning policies and obviously tangible harm if we're going to refuse an application. So I'll just remind members of that. I think there was one other point, but it slipped my mind. Apologies. If you wouldn't mind just reminding me. Thank you.
Sustainability.
Yes,
the sustainability side of it.
So in terms of as a district, we have in the core strategy, and it would be transferred over in the section 2 plan when that gets formally adopted. But we do have what we call a settlement hierarchy. So obviously we have the main towns, Braintree, Witham, Howstead, and then we have the key service villages. So the key service villages are the ones that are seen as having not as many services as the main towns, but enough to be able to accommodate, moderate sized development proposals that have, access to public transport, access to a school, and other facilities that, to meet, needs of future residents. Now, and I appreciate comments about, capacity and things like that, but as far, for officers' deliberations, we have to look at, is there provision available? Yes, okay, well that then, and it's in, it's in well within Hatfield Peveril, this site, because of where it would be classified as a, reasonably accessible location. The sustainability is actually the whole planning balance. So the accessible location of Hatfield Peveril is just one of those factors, if you like, that all sort of come together at the end in the planning balance.
Thank you. Sorry, that's not quite what I meant. I meant in terms of charging points, photovoltaics, sustainability.
Just wait till I invite you back, please. You can't just jump in, please. Right, carry on now.
So it was specific to the site, the actual sustainability elements of the site in terms of rainwater recovery, photovoltaics, charging sites, that charging points, that sort of thing that might not necessarily have applied on the previous one, but would now apply, and certainly things that we would consider on this site.
Thank you. Sorry, my apologies for the confusion. So there is actually a condition now which requires an electric vehicle charging scheme. So that would actually make it comply with the neighbourhood plan in that respect. So yeah, we'll get some details of that. In terms of solar panels, I think it's an argument that, or it's certainly something that members have put forward before. Unfortunately, officers' answers is the same. We're not able to, require those sustainability features to come forward on developments like this. It comes down to the building regulations. We lost the power to, like Code for Sustainable Homes and other mechanisms which allowed us to secure, like sustainability measures. We don't have that anymore. So with the electric vehicle charging, there is a policy in the neighbourhood plan about that. So we were able to put a condition on, and the developer was happy with that. So there is a condition in the report.
Thank you, Matthew. Before I go to Council, Mrs. Parker, I'm going to invite Chris Padgey, who wishes to speak at this stage, please. Chris.
Thank you, Madam Chairman. I just wanted to come back on just a clarification point, just in relation to the amount of weight in relation to the plan. So just picking up on the point that Councillor Abbott just made. So obviously members would have noted within the agenda papers, we've updated the standard text at the start of each of the reports that deals with the development plan and the amount of weight that can be attributed following adoption of section 1 of the new local plan. In relation to section 2, that's obviously subject still to examination. So obviously, while the amount of weight to be attributed to policies is for the decision maker, officer advice would be that the amount of weight that can be attributed still to section 2 of the plan is still limited, because it's still got to go through that examination process as part of the hopefully towards the adoption of the new local plan in its entirety. So I just wanted to clarify that point, because certainly from officers' perspective, we would advise only limited weight can be applied still at the current time to section 2 of the plan. Section 1 obviously now being adopted, we can afford the full weight. So I just wanted to clarify that point, Madam Chairman, and with apologies as well, I just wanted to just elaborate on one point that Matt raised in response to Councillor Unsworth's question, just in relation to restrictions within gardens. Matt sort of set out, obviously, there's no restrictions on any applicant developer coming in with a planning application. We have to consider those on their own merits. You do occasionally have situations where there may be restrictions or covenants on the deeds for particular properties. That's not a planning matter for us as the local planning authority or for members of the planning committee. It comes down effectively to a legal right as to whether or not an applicant or an individual developer is able to do something. So the grant of planning permission never overrides those type of covenants or deeds. We need to consider the application before us on the planning merits, but you're right to reference it, because there are occasions where those type of restrictions will exist on the use of land, but it isn't actually a material planning consideration that we are able to take into account. So hopefully those comments are helpful, Madam Chairman.
Thank you, Chris. Councillor Mrs. Parker.
Thank you, Madam Chairman. And I've listened carefully to the speakers and also to comments that have already been made. In particular, I do note what Councillor Mann was saying about the harms that have been, well, identified or in the appeal decision, and the, in fact, limited harm on that site. Having said that, I just want to pick up a couple of points that were made by the first two speakers and also ask a couple of questions. So I'm sort of slightly struggling with why development outside the boundary of the village complies with the local, the neighbourhood plan. And I note what has been said on page 14 of the agenda, in particular, the point that the neighbourhood plan doesn't contain policies or allocations to meet housing need. But as was pointed out by the speakers, and as when I looked on our website and looked at the neighbourhood plan, I came across a document entitled Site Assessment 2017, which identified the housing need according to the neighbourhood plan of 78 homes, with the site to be allocated, which is the Berry Farm, Arla site, Sorrelsfield site, which accommodated 173 homes. And also the speakers have talked about the allocations for Hatfield Peveril significantly exceeding the objectively assessed housing need. So I just would like a further explanation, please, as to why it is felt that the neighbourhood plan doesn't contain any policies and allocations. I mean, it is quite difficult, I think, for a neighbourhood plan to add additional sites if there are already huge numbers of sites have either been allocated or granted permission well in excess of the housing needs. So I just would like, please, some clarification on that. And I note that Mr. Wilkinson said we'd received our council's advice on that. So I would be grateful for clarification on that. The second point I'd just like to pick up on, please, is whether there is compliance with the neighbourhood plan policy F13 regarding education, because that policy does say that there must be evidence that there is sufficient educational capacity. I note the officer has said that the Essex County Council have not requested a payment towards education, but there is no evidence as to where the children will be educated who are probably going to live in these houses, and whether there is sufficient capacity, particularly within the village, and whether it's adequate to require them to travel elsewhere. So I'd like an answer on that, please. The third point, please, is in relation to the comment from the officer that we don't need, are not entitled to require any affordable housing. I note that the applicant in both this case and the appeal case is described as the same person, and a similar company, very similar name company, but presumably the land ownership of the two sites is different. So if the land ownership is different, but the applicant is the same, the developer is the same, are we not entitled to apply for affordable housing? And the final question, sorry, rather long list of questions, is on this. I am a bit concerned about the situation with refuse, because I note in the officer's report, he said that there has been quite complicated to try and agree a refuse strategy with a neighbouring site. These, I presume, are all going to be private roads, obviously backland development. So what is it? I note that in the proposal is to leave this to be dealt with by condition, but I'm just a bit concerned that leaving it to condition without us having any idea of how this refuse will be collected. Perhaps you could address that point as well. Thank you.
Thank you, Councillor Mrs. Parker. Over to you, Matthew or Chris.
Thank you, Councillor Parker. Well, I've made a note of all the questions this time, so hopefully I'll be able to come back to you and not get confused. So just start with the refuse then, probably the easiest one. So what we agreed on the appeal site with and obviously speaking to colleagues in the refuse team, was that they would go up and access the private road with an legal indemnity against any damages to said road. So the road can accommodate a refuse vehicle, and what the proposal in this case is effectively to do the same thing. So basically extend that indemnity to include the bit of land that we're now referring to, which would, the refuse guys are happy with that as an approach, and certainly the inspector sort of said on the appeal site that that's kind of what we could have done, that he wasn't really worried about it. So it was something that we historically raised, and we've come to a resolution, and then again we're seeking to apply the same resolution, if you like. In terms of the neighbourhood plan, so I think the wording is very careful in that it, as has been alluded to, it was something that we deferred the item from the committee last time just to make sure that we were in the right position to advise members on the neighbourhood plan, and we have had some legal advice on that position, and as you see in the report is the legal, has been checked by Count Selwyn, is legally sound. I wouldn't say that the proposal complies with the neighbourhood plan per se in terms of that. It just doesn't conflict with it, because it doesn't, strictly speaking, it doesn't allocate any housing sites. So and the other things comply in terms of the well, maybe apart from education perhaps, but we'll come back to that. But in terms of the things like electric vehicle charging, in terms of design, that is all still relevant. That is still the neighbourhood plan. It's not disregarded because it doesn't contain any policies which allocate development. It's just when we're looking at the proposal from a pure, is the tilted balance engaged or not perspective, because it doesn't allocate the sites in accordance with paragraph 14, it effectively means that we have to then engage the tilted balance in favour of development. We can't, if there was allocated sites there and it met the other criteria, then we could potentially say, actually, no, we don't need to engage the tilted balance, and therefore potentially make a different decision, potentially. But in terms of where we are with it, it's not it just doesn't conflict with it, rather than it complies with it in terms of that particular point. In terms of the affordable housing, so yeah, so it is so we, as set out in the report, we have looked at case law around this, and yeah, I mean, it's a difficult one. I think with the, even though the applicant is the same, it's a land promoter. It's not the actual the landowners were very different. Certainly with the original one and with this one, and the appeal site has now effectively been built out. Because of that, because of the different ownership, effectively we would be unable to sort of combine them together and require a contribution, because if we were, that would be unlawful and unreasonable, and yeah, we could potentially be liable to, if the developer appeal, we could be liable for costs against us, because there is case law around it. So yeah, it's not straightforward, but in this case, it has, the 7 dwellings on their own don't require affordable housing because they're below 10. They don't require an open space contribution because they're below 10 dwellings. So we have to consider it on its own merits, even though I know the other site is next to it. We have, it's not reliant, that site is not reliant on the 7, if you will, that we're now looking at. So yeah, I hope that sort of helps that with that one. In terms of no evidence of capacity, I'd invite Chris if he's got any comments on that. But other than that, I think that's covered your points. Thank you.
Thank you, Matthew. Chris, did you wish to come in on this point, please?
If I may just briefly just elaborate just on that point around the neighbourhood plan that Matt's just mentioned, is I think the key point for members really this evening, it's the second and third last paragraph at the bottom of page 14 of your agenda papers, in relation to the neighbourhood plan not containing any policies on allocations. I think this is the key point from our perspective, and this is the point that we've tested with Council. So I think we have to recognise, obviously there is a sensitivity around this. A lot of work has gone into the neighbourhood plan, and a lot of good work has gone into producing the neighbourhood plan locally. And it may well have been the intention that as part of that process, the neighbourhood plan would have afforded some protection for proposals and developments like this. The situation, however, that we are in with the neighbourhood plan from a development management perspective is that neighbourhood plan for the first time is being tested, and we are having to look at the policies that are actually included within the neighbourhood plan and whether or not they actually afford any protection. And this is where, unfortunately, we've come to the view here that we don't feel that it does afford the protection for these type of proposals, and hence that's why we did seek Council opinion on this, given it's quite a fundamental issue. But those the bottom part of page 14 are really the key elements there in relation to the neighbourhood plan, and our overriding conclusion is there is no conflict with the neighbourhood plan that would allow us, in our view, to provide a robust reason for refusal on those grounds. Just on the education point that Councillor Parker raised, so absolutely accept what the neighbourhood plan states in respect of this. The problem is Braintree Council, with the relevant local planning authority, we're not the relevant local education authority. That sits with the county council, and their own adopted guidance in terms of seeking developer contributions to mitigate development is set out within their infrastructure development guide, and the proposal in this case falls below the threshold. So this is a point that we have queried with the county council. Matt has had discussions with colleagues at the county council. It is their standard policy position at the moment that they would only seek contributions to mitigate education places for developments over a certain scale. So in the absence of the policy justification for seeking it and actually securing the contribution as the local planning authority, Office of Rights is that we don't feel that would be a ground or reason for refusal here. We would need the support of the county council to be able to demonstrate that a contribution was required, and then that would then go towards mitigating the impact of the development through the provision of additional education provision locally or within the local area. So thank you, Madam Chairman. That was the clarification that I wanted to provide in response to Councillor Parker's question there.
Thank you, Chris. Councillor Abbott.
Thank you, Madam Chairman. I'd like to move refusal, please. I could put a lot of things in, but I've listened very carefully to what officers have said. So I'd like to move refusal on the grounds that this is an unallocated site in the countryside and backland development.
Thank you, Councillor Abbott. Does that find a seconder?
I'll second that, Councillor Chairman.
Thank you. And before I move this, Councillor Mrs. Parker wishes to come back, and I just wonder if she could ask her question quite quickly. We've spent nearly an hour on this application, Councillor Mrs. Parker.
I will be quick, Madam. I just wonder if Chris could just clarify again. I mean, the point about the neighbourhood plan with the education is there is no evidence that there is sufficient educational capacity, and the neighbourhood plan requires evidence that there is sufficient neighbourhood capacity. I understand the point about getting developer contributions, but you can ask for a sum of money, but if there's nowhere to send your child to school, that's not going to help. So I was just wanting to understand whether that requirement within the neighbourhood plan was met, has been satisfied. And the other point I just wanted to just clarify again about the affordable housing. I know Matthew has tried to answer this question, but I mean, my understanding is that the developer / promoter is the same person. They are the same people on both the appeal documents before us and in the application. And so and also I think the site was advertised as, phase 2 of the same development. So I just wanted to clarify that we really are not entitled to any affordable housing in those circumstances. Sorry, Madam Chairman.
Many times before, Councillor, and we've not been able to do it, but I will ask Chris to come back before I move on.
Thank you, Madam Chairman. So just in response to the education provision, so I absolutely fully accept the point that's being raised, Councillor Parker, and the concern. I suppose my counsel to the evidence point is the fact that the Education Authority, who have the statutory responsibility for providing those education facilities locally, has not raised an objection to the proposal, saying there is insufficient capacity. So my concern in an appeal situation, if the application was to be refused on those grounds, is we'd be faced with a situation where a planning inspector would be saying, where is the support for the contribution that's required to mitigate the impact of the development? And that would have to be produced from the statutory body that's responsible for education, which is the County Council. So I would agree with you that if we had a situation where the County Council was raising an objection here, then that is a matter that we could then raise, but they're not raising an objection. And therefore, again, our conclusion would be it doesn't conflict with the neighbourhood plan in that instance. And it is the adopted ECC policy that there is this threshold in place. So they are applying their policy consistently in that regard. In respect to the affordable housing, I think Matt has already answered that point about the subdivision of the site. I think from our perspective, this is something that we do look at very closely with sites to make sure there isn't being an artificial subdivision. I think the point about the phase 2 and the marketing around that, it seems eminently sensible from a marketing perspective. But I think we're as satisfied as we can be as officers that there isn't a basis here to be able to require that contribution reasonably, and then in the event that that wasn't agreed, be able to successfully defend that appeal situation. So again, hopefully those comments are useful.
Thank you, Chris. Now we have a proposal on the table. We have Councillor Abbott has moved that we refuse this application. It has been seconded by Councillor Unsworth. I'm going to put that to the vote at this stage. Councillor Abbott, this is in favour of refusal. I don't know how quite to word this.
Yeah, for refusal.
For refusal. Okay, thank you. Councillor Bowers.
Abstain.
Councillor Cunningham.
Against.
Councillor Horner. Councillor Horner.
Yes. Against.
Thank you. Councillor Johnston,
For refusal.
you're for refusal. Thank
Yes.
you. Thank you. Councillor Mann,
Against.
Councillor Monday,
Against refusal.
Councillor Mrs. Parker,
Reluctantly against.
Councillor Ritchie,
Against refusal.
Councillor Mrs. Spray,
Against.
Councillor Unsworth,
For refusal.
Councillor Wrench.
Against.
Members, that has fallen, so we now have to go to a different vote. I need someone to move something, please. Councillor Mrs. Spray, sorry, I'm just looking at your picture rather than the chat function. So
I was
so
trying to-
sorry. So
That's all right. I was trying to decide whether to wave at you or put something on the chat function. I would like to move officer's recommendation for approval, please, Chairman. I do not think we have any sound planning grounds for refusing this. Thank you.
thank you. Does that find a seconder?
Seconded, Madam Chairman.
Thank you, Councillor Cunningham. Thank you. So I'm now going to put the officer's recommendation, which is for approval, to the vote. Councillor Abbott,
Against.
Councillor Bowers,
Abstain.
Councillor Cunningham,
For.
Councillor Horner,
For.
Councillor Johnson,
Against.
Councillor Mann,
For.
Councillor Monday,
For.
Councillor Mrs. Parker,
For.
Councillor Ritchie,
For.
Councillor Mrs. Spray,
For.
Councillor Unsworth,
Against.
Councillor Wrench.
For.
Thank you, members. That application has been approved. Thank you very much indeed. We now come on to application number 20-01513, full 23 Greenfields, Gosfield. We have no one making a statement on this application this evening. So I go straight to Matthew again to make the presentation, which can be found on pages 39 to 54, members. Thank you, Matthew.
Thank you, Madam Chairman. Bear with me while I share my screen. Okay, hopefully you can see that.
Yes, thank you.
This presentation, you'll be pleased to know, is a bit shorter. It's for the erection of one dwelling, one detached dwelling, and the creation of a new access at 23 Greenfields in Gosfield. So the site is in red, as you can see. 23 Greenfields is in blue. So what we're looking at is effectively a subdivision of the site. The plot itself, if you take it in its totality, is generally wider than other plots in the area, as you can see from this plan. Yeah, just a couple of other points. The Sandpits Nature Reserve is at the rear, which wouldn't be affected. Unlike the other application, this one is within the settlement boundary of Gosfield. So I've included a context plan just to show, some more finer detail, I guess, that's missed. So I've starred where the site is, and you can see the existing property, number 23. There is a hedge and some conifer hedges at the front of the site, which we'll see in the site photos. Just in terms of a bit of a character assessment early doors, we've got some bungalows here to the south, and then in terms of the properties to the north, it's 1.5 story, 2 story. So there is quite a mixture of dwellings in the street scene, and I'll show you that. Okay, so the existing site layout, so it is a bungalow that's there, number 23. The householder application that was on block this evening was also for this site, but it was to actually raise the roof of number 23. And as we go through the plans, you'll see that this changes to reflect the proposals in that householder application. And I'll explain that as well. Okay, so the application proposal. So yeah, so with the bungalow number 23 to start with, so that now effectively has accommodation. That it's still primarily it's 1.5 story now, with accommodation upstairs. So what we're looking at with this dwelling is a bungalow appearance at the front, but with first floor accommodation at the rear. And you'll see that in the elevations in a minute. But just to try and, I guess, make it blend in with the street scene and with the existing property, whether that household application gets implemented or not. Okay. So while the proposed dwelling might be in close proximity to its side boundaries, it wouldn't be uncharacteristic of some of the other properties in the area. It would provide internal and external amenity space in accordance with the standards set out in the Essex Design Guide and National Described Space Standards. Officers therefore consider that the proposal wouldn't represent a crammed or overdevelopment, which is what has been suggested in some of the representations. A parking isn't shown, but there is sufficient space for 2 vehicles to park off street in accordance with the standards. It's a 30 miles per hour road, so if vehicles have to reverse onto the road, that's not detrimental. And certainly is probably the situation for a lot of the other properties in this road. In terms of its position adjacent to number 25, it doesn't really go much further back than the existing rear, so and it's also separated by the garage, so there wouldn't be any detrimental impacts on that property as far as officers are concerned. And similarly with number 23, it is closer to number 23, and there is number 23 is quite unusual in that the primary outlook is in the front elevation effectively is this direction, and it's almost sides onto the road. But with the proposal there, officers are of the view that there wouldn't be sufficient harm on the amenity of this occupier to justify refusal in this case. There will be some harm, but it wouldn't be so significant in officers' view. Just in terms of elevations, you were pleased to know they're not black in colour. I'm not sure why the plans show that, but it's there. This envisages that it's going to be buff brick. So, as I said, it's more akin to a bungalow at the front, or like a tall bungalow, and then at the rear you've got the sort of the first floor accommodation really. So, yeah, it's as I said, it's to try and sort of blend that dwelling into the street scene as far as possible. And then the street elevation. So this shows the householder application which has been approved this evening at the work. So it does have a better street frontage, and you'll see from the site photos what it is at the moment. But it does provide a better frontage, and they sort of correlate with each other quite nicely in terms of the the ridge heights and such like. So just in terms of the floor plan, so bedroom 1, bedroom 2 and 3 at first floor, and then the living accommodation. As I've said, it's big. It's larger than the required standards in the National Described Space Standards, so we'll provide good amenity. You've got various openings as well at the front and at the back, so it's dual aspect. And then, yeah, just going through some of the pictures. So the site is here. As I said, it's quite unusual in that it doesn't really address the road frontage very well, and that it's along this frontage here, so it is quite well screened at the moment. You can see the number 25, which is the bungalow next to it here, and then I suppose, turning approximately 90 degrees. The bungalow we're just looking at is just here, and then you can see the other two bungalows, and then it sort of changes the street scene to 1.5 story, but fairly mix of character. Okay, so turning back around, looking, so that's the site is here. Looking up the road, you can see that there's some 2.5 story over here, 1.5 story here, and 2 story up here. So, as I said, it's very mixed, and obviously you've got the bungalow opposite. Okay, so I've walked up to the other side of the site now. So I've got the 1.5 story dwelling to the north, and then you've got the existing property here, number 23, and the garage, and that is looking directly at the front, well, the elevation that fronts the road. So you can see it doesn't really have any sort of a formal address at the moment, which would change as part of this agreed household approval. And then, yeah, looking at the this bit of land here. So at the moment it's domestic garden, and that would then change to obviously accommodate the new dwelling. That's looking towards the nature reserve at the rear. That's just showing a bit of a closer relationship with the number 25, and you can see its garage. And that's the elevation that would front onto where the dwelling would be. So as I said, it is there, like their front elevation. I think it's important to note that with the householder approval, there is a new entrance proposed in the front, that will front the road. So yeah, so that wouldn't be the primary entrance anymore. And then, so it's just, so the road's just along here, and that's the property, the side of the property that fronts onto the road. Some of these trees and hedges, which I think primarily are conifers, would be removed, but these are of no great value as is commonly accepted. Yeah, and again, it's just the same, a picture showing the same thing, but just slightly a better view, if you like. And then this is another view of the other side of the property. So one dwelling within settlement limits towards the housing supply. It wouldn't be detrimental to the character of the area. It actually responds quite well, I think, given the mixed character. Internal and external amenity and parking provision all provide in accordance with their relevant standards. No detrimental impact on neighbouring properties or even the existing occupiers of number 23. The access arrangements are satisfactory in Essex Highways. Haven't raised an objection. There would be some loss of trees at the front that I've shown you, but these are limited amenity value given their species. And we're actually outside of a HRA area, so no HRA is required for this particular development. So tiltway balance applies. Officers consider that the benefits would outweigh the harms in this case, and therefore the recommendation before you this evening is to approve the application subject to conditions. Happy to answer any questions. Thank you very much.
Thank you, Matthew. Thank you very much indeed. Councillor Cunningham.
Thank you, Madam Chairman, and thank you, Matthew, for that presentation. I appreciate there are differing views on in-garden or infill development, but we have a responsibility to look at this objectively within the planning framework. And infill development and building in gardens has been probably a feature of the Braintree district for decades, from Braintree to Bulmer, from, I don't know, Fairstead to Coggeshall. We have to judge each individual application on its individual merits and in line with planning policy. I think this application is sensitive to the local area. I think in terms of design, it is of a higher standard than some applications. I particularly think the front of the property, a bungalow merging into a first floor, provides an interesting and a slightly different housing unit into a particularly nice area that has a good mix of different sized houses in Gosfield. I appreciate the points raised about amenity and the fact there has been no highways objection. I think the natural screening also helps mitigate some of the obvious concerns that the next door neighbour will have with this application. Therefore, Madam Chairman, with that in mind, I'm happy to move recommendation for approval. Thank you.
Thank you, Councillor Cunningham. You sound as if you're in a fishbowl again, Councillor. Councillor Mann, you wish to speak. I have to, I'm sorry, does it find a seconder before I move on?
I'll second it, Chair.
Thank you. You wish to speak?
I know the site quite well. I've been a sort of a frequent visitor to this small estate in past years, and I think, as the officer report says, the relatively simple design of the dwelling doesn't conflict with the existing character of the area and in terms of appearance and amenity and layout. I think they all would meet policy criteria. So happy to second, Chair.
Thank you, Councillor. Does anyone else wish to speak? I have no one on the chat function indicating that they wish to do so. No. Well, I'm going to put that to the vote. It has been moved by Councillor Cunningham and seconded by Councillor Mann that we approve this application. Councillor Abbott.
For.
Councillor Bowers.
For.
Councillor Cunningham.
For.
Councillor Horner.
For.
Councillor Johnson.
For.
Councillor Mann.
For.
Councillor Monday.
For.
Councillor Mrs. Parker.
For.
Councillor Ritchie.
For.
Councillor Mrs. Spray.
For.
Councillor Unsworth.
Abstain.
Councillor Wrench.
For.
Thank you, members. Members, that application has been granted. Thank you very much indeed. And thank you, Matthew. We now come to the application 5C, application number 20018824, land to the rear of Charwin, Cross End, Pedmarsh. And I do have one speaker on this application, and the speaker is Miss Hayley Webb. She is the agent. Miss Webb, are you with us?
I am, thank you. Good evening, Madam Chairman. Good evening, all. Planning permission has been granted and is extant for the erection of 2 large detached bungalows at this site. Under this permission, the approved works in respect of utilities have commenced. The principle of a residential development has been accepted by the LPA and also the planning inspector when allowing the recent appeal. The applicant is seeking an optimum development of 4 detached bungalows, which are individually smaller than the bungalows approved. Overall, this will create a good quality and attractive development. Due to the vastness of the application site, the proposed development can be achieved without any amounting to overdevelopment. The proposal complies with the adopted standard in respect of vehicle parking. It accords with the national space standards and also exceeds the required amenity space. The bungalows are positioned with adequate distances to boundaries. There will be no occurrences of overlooking, overdominance and or overshadowing between each bungalow and also to the existing properties along Pedmarsh Road. During the consultation period, third-party comments raised concerns in respect of the roof space being converted to form habitable accommodation, which could then result in possible overlooking. The applicant has welcomed a condition to remove the resultant dwellings' permitted development rights in order to prevent this from happening. The application is accompanied by updated specialist reports relating to transport, ecology and trees. The reports conclude that the proposal can proceed without any detrimental effects to highway safety or harm to ecology and trees. The statutory consultees have also accepted the content of the reports, raising no objections and recommending suitable conditions. In respect of highway safety, it is noted that concerns have been raised by the parish council and third parties in relation to the existing access. In updating the transport statement, the correct ownership has been outlined. The statement continues to conclude that the existing access and visibility displays are adequate and the development can proceed without any detrimental effects to highway safety. The statement also confirms that the site is sustainably located and that the additional 2 dwellings will be minor in respect of vehicle trips. In providing their consultation response, the local highway authority have accepted the supporting statement and raised no objection. Due to the LPA not being able to demonstrate a 5-year housing land supply, the NPPF prevails. The proposal is wholly in accordance with the NPPF, representing a sustainable form of development, which again has been accepted by both the LPA and planning inspector. The LPA have assessed the current proposal and confirmed it's acceptable in respect of location, access to services and facilities, layout, design and appearance, residential amenity, highways, landscaping and ecology. The LPA have concluded their assessment and recommend approval. Councillors are respectfully requested to follow the planning officer's recommendation and grant planning permission subject to suitably worded conditions. Thank you very much. Good evening.
Thank you very much, Ms. Webb. Thank you for being quite speedy with your statement. And we'll come now to the presentation. And the presentation is going to be made by Lisa. Thank you, Lisa, if you are ready.
Thank you, Madam Chairman. Okay, this is a full planning application for the erection of 4 detached bungalows with associated garages, access and amenity, and its site land to the rear of Charwins in Cross End, Pebmarsh. The application is being reported to committee in accordance with the council's transitionary scheme of delegation, as the parish council object to the proposal contrary to officer recommendation. Here is a location aerial photograph. You can see that the application site here is located to the northeast of the village of Pebmarsh. It lies outside but adjoining the development boundary. This blob here, which I have imposed on this aerial photograph, is just a rough indication of the site. Here, looking again at the location plan, you can see that the site is to the east of Pebmarsh Road. It's lying behind the dwellings that front onto that road. To the north is a residential property and associated land. To the east are agricultural fields and a public right-of-way. Whilst to the south, the site partly lies with the boundary with Elm View, the residential property there, and further agricultural fields. The site is accessed via an existing track between Charwins and Poppy Fields. And as noted within the report, the site has permission for the erection of 2 detached dwellings, which remain extant, and work has commenced on site to install utilities. Turning now to the proposed block plan, the application, as we know, seeks 4 detached single-storey dwellings with associated garages. So plots 1 and 2 here are located within the northern parcel of the site with a shared double garage. Plots 3 and 4 to the south, again with a shared double garage. The dwellings, as I've noted, are all single-storey, which reflect the scale of dwellings in the locality. Vehicular access is taken here onto Pebmarsh Road, which is an existing crossover shared between the site and Charwins. The access then extends between Charwins and Poppy Fields to the sites. Central to the sites, we can see a turning provision, and the dwellings are also provided with a temporary bin store location located at the frontage here, where bins will be located on bin collection day. So turning to the floor plans, we're looking at plot 1 here. It's a single-storey 3-bed dwelling, and plot 2 is the same 3-bed, just handed. In terms of elevations for plots 1 and 2, this is the elevation that would front into that internal access road. Looking at the rear and the side elevations of plot 1, and similar the side and rear elevations of plot 2. So plot 1 is constructed with a red brick and a plain tile roof, whereas plot 2 we're looking at now is painted render with a red brick plinth, also with a plain tile roof. As I noted, the garages are proposed. So there's 2 double garages, 1 to the north and 1 to the south. They are split, as we can see here, central. So each of the units are allocated 1 garage space. Turning to plot 3, which is located to the south. This is a 3-bed unit with study. These are the elevations. So again, we can see the red brick, render and the tiled roof. Plot 4, also to the south, is a 3-bed with study. And it is similar materials, so the red brick with the tiled roof. The application has also been submitted with a construction method statement. This was also submitted as part of the discharge of condition application for the extant permissions. This includes areas for storage, parking, hard standing and turning facilities, wheel washing, and other matters such as site office and secure store. The application has also been submitted with the tree protection plan. This demonstrates that the dwellings are sited outside of the root protection areas. A number of 4 trees here are to be removed, so T8 to T11 are to be removed. These are considered to be low quality trees, and their juxtaposition to plot 4 here would not be suitable. Officers consider that these trees provide no wider public amenity and can be replicated with new replacement trees on site, and this forms one of the conditions. Now, looking just at some photographs here, this is the northwestern boundary with Charwins on the left-hand side. You're looking towards the northern boundary. That northern boundary again, this landscaping lies outside of the site area. The eastern boundary here, where the majority of the existing landscaping is, and again lies on the adjacent field. And looking at the southern boundary here. This is a photo of the trees to be removed, so it just gives an indication to members in terms of the quality and the impact those existing trees have. And a photo here of the southwest boundary with those residential properties beyond that front onto Pedmarsh Road. Here is a view from the development site looking down back onto the access, so back onto Pedmarsh Road. And another view from the other angle, so standing on Pedmarsh Road looking into the application site. There is a change between the access, some of the specification around the access from the extant permission. So on this, the access has been widened slightly and some of the hedges have been cut back on either side. And here is another view just looking up towards the access site. You can see here, so looking north, the access site here again as you're looking south. So a quick, there is a member update, and that's in regard to condition 3 on the agenda. Condition 3 outlined it within the agenda, and that's relating to levels. So we have subsequently to the report being drafted had a full levels plan submitted to the local authority, and we have considered that to be acceptable, and therefore officers are seeking to change condition 3 to be a compliance condition, and therefore we're also seeking to add that amended plan as an approved plan. So in terms of the planning balance and the conclusion, the principle of development is accepted, and this has been addressed by the inspector in allowing the appeal for 1 dwelling and within the application for the erection of a further dwelling on the site. The site effectively adjoins the development boundary, and the development would therefore make a small but positive contribution to maintaining the viability of rural communities. There would be some social, economic and environmental benefits. No harm has been identified in terms of the other planning considerations, and on balance, highway matters are considered acceptable. And therefore, when considering the planning balance and having regard to the requirements of the NPPF as a whole, officers have concluded that there are no adverse impacts that would significantly and demonstrably outweigh the benefits when assessed against the policies in the framework taken as a whole. And therefore, officer recommendation to members this evening is that planning permission is granted, subject to that change to condition 3 relating to levels. And that's the end of my presentation. Thank you.
Thank you, Lisa. Thank you very much. I was having mouse problems. I'm confused.
Chairman, you have Councillor Cunningham wishing to speak first.
It's just you haven't put the application, so I was still looking at Greenfield. Sorry.
Oh, I do apologise, Chairman.
That's all right. That's all right. I now know where I am. Sorry. That's okay. Thank you. Councillor Cunningham, sorry, mix up on my behalf.
Thank you, Madam Chairman. I'm sitting as far back as I possibly can to
That's
help
better.
the audio experience, and I hope it's working.
It is, yes.
Good. Thank you very much for the presentation. I think there's a lot that you can find favour with this planning application. I appreciate the point that it is outside the development boundary, but I think the point about viability to rural communities is an important consideration. In terms of design and layout, again, I think that's highly favourable, good design in terms of layout and also good design in terms of the actual properties. Bungalows are a desirable addition to local housing supply, and in a rural community particularly even more so. Without any statutory without any issues raised by the statutory highway authority, again, it's difficult to find grounds to refuse this planning application. Therefore, with the additional condition outlined by the officer, or sorry, the change condition outlined by the officer, I'm very happy to move approval on this application. Thank you.
Thank you, Councillor Cunningham. Does it find a seconder before I move on?
I'll second, Madam Chair.
Thank you. I have you to speak next anyhow, Councillor Mans. Would you like to speak now, please?
Thank you. Well, the principle of development very firmly established, including by appeal decision. So we're presented with a choice between two large detached bungalows, which have secure permissions, and 4 slightly smaller ones. And I see no real policy reasons why we shouldn't allow this, Chair. So happy to second.
Thank you, Councillor Mann. Councillor Abbott.
Thank you, Madam Chairman. Yes, I think the difference on this one is, although it's more houses, it's on the same footprint. My question to officers regarding the trees is the photographs shown seem to show the entire site had been cleared pretty much. So are officers saying that those trees to stay in the root protection areas relate to trees outside the boundary, or have trees been removed which were originally proposed to be kept?
Thank you, Councillor Abbott. I'll ask Lisa to answer that before I move on to Councillor Mrs. Parker.
Thank you. My understanding is that no trees have been removed from the site as yet. So those 4 trees that we're seeking to, that the application seek to remove, are still on site. So the root protection area, the majority of the trees are on the boundary or lie just outside of the boundary. So the boundary isn't really defined, particularly on the eastern boundary with that agricultural land and the footpath beyond. There isn't sort of a defined boundary line there at the moment. So it's somewhat difficult to see actually whether on the development site or whether they just lie outside of it. But the arboricultural report is quite clear in terms of the extent of root protection area.
Thank you, Lisa. Thank you very much. Councillor Mrs. Parker.
Thank you, Madam Chairman. Yes, I'll be very brief. I entirely agree with the officer's recommendation and their reasons for it. I just want to say that I have a very similar development to this in my own village, 4 small bungalows in a site behind some other houses. Was actually a brownfield site, but it's slightly different from this, but it is actually a very successful development, and I think this one will be too. Thank you.
Thank you very much, Councillor Mrs. Parker. Anyone else wish to add anything further on you? No. Well, it has been moved by Councillor Cunningham and seconded by Councillor Mann with the change to condition 3 on the levels. I'm now going to put that to the vote. This is in favour. Councillor Abbott.
For.
Councillor Bowers.
For.
Councillor Cunningham.
For.
Councillor Horner. Councillor Horner.
For.
Thank you. Councillor Johnson.
For.
Councillor Mann.
For.
Councillor Monday.
For.
Councillor Mrs. Parker.
For.
Councillor Ritchie.
For.
Councillor Mrs. Spray.
For.
Councillor Unsworth.
For.
Councillor Wrench.
For.
Thank you, members. That has been granted unanimously. Thank you very much indeed. Now comes onto the next application, which is 5D. Application 20020068 full, Rosemead Fairstead Road, Turling. I have 2 statements and they are both going to be read by Alison. And the first statement is from the Turling and Fairstead Parish Council, who are objecting. So Alison, are you available to read the statement for me, please?
Yes, thank you, Madam Chairman.
Thank you.
Statement by Turling and Fairstead Parish Council. As statutory consultee, the Parish Council seeks to draw to your notice that only some of its considered representations to BDC have been included in the officer's report before you. The Parish Council now seeks to restate and amplify those important, missing and relevant concerns. Without exception, this site has been the most active in planning terms in our parish in at least the last 20 years. Your officer's report correctly details these. In our opinion, this is clear evidence of planning creep, and the application before you perpetuates this. In our representation, we have drawn attention to the specific nature of the proposal. In the assessment of the planning balance, your officer's report chooses not to make comment on the bespoke features and specification of the design considerations within the application. By our estimation, 13% of the floor area of the accommodation is identified for special needs. The applicant's understandable aspiration is to provide lifetime housing for his family for the future, and as such, BDC Policy 22, lifetime housing, should form a critical part of your officer's assessment in the report before you, and their summary recommendations to approve. In the opinion of the Parish Council, it does not. The Parish Council would now request and expect your officers to recommend conditions to be attached to any consent your committee may decide to grant to demonstrate and comply with that stated policy for future occupancy of this bespoke development. BDC Policy RLP 22 advises in the narrative under paragraph 3.38 that provision should be made for external play areas for the special needs children. It also cautions these play areas should be safeguarded to maintain the privacy and amenity of neighbouring properties, and BDC should impose planning conditions to that end. There is no landscape proposal that attends to this requirement. We have drawn officers' attention to previous consents where landscaping protection was conditioned, for example in paragraph 4 of BDC consent 17/00330, and we would request this needs to be addressed for consideration in a comprehensive landscape design as part of this submission, or certainly in reserved matters. We have previously requested that, as a condition of any consent, external lighting should only be at low level and with timing devices fitted, rather than attached as an informative, as in consent 17/00330. We request that now all existing and future external lighting should be so conditioned. We note that your officer reports a representation of support from a neighbour. That respondent is not on the electoral roll in this parish, and weight should therefore not be applied to that representation. The Parish Council would welcome the opportunity to comment on detailed reserved matters / conditions yet to be made to BDC officers and prior to the issue of formal reserved matters consent documents. Thank you for permitting us to make this statement to your committee. That's the end of the statement. Thank you, Madam Chairman.
Alison, thank you very much. You have one more statement to read, and that is from Mr. Chris Game, who is the agent for this application. Thank you, Alison.
Thank you, Madam Chairman. This is the statement of Mr. Game. Dear members of the Planning Committee, this statement has been prepared by Place Design Company Limited, who are acting as the agent on this application. This planning application seeks to secure consent for the construction of a replacement dwelling in a residential area which is within a defined settlement boundary, but outside of the Turling Conservation Area. The replacement dwelling will be a two-storey detached property
comments about the amount of development generally in that area.
Thank you, Councillor Abbott. Well, members, no one else has indicated they wish to speak, and it has been moved and seconded that we grant this application. I'm going to put that to the vote. That is with we want to put an well, are we going to do about the hedge? How are we going to word that? That we wish the hedge to be retained during the works or forever? I'm not quite sure which you want to, Councillor Cunningham.
I think, well, was it informative to protect the hedge during the construction period? Is that what we're seeking, I think?
Yeah, I think that's what was being sought, yes. So we have with an informative to protect the hedge during construction, and a change of condition 3 to a compliance condition. All those in favour, I'm going to put to the vote now. Councillor Abbott.
For.
Councillor Bowers.
For.
Councillor Cunningham.
For.
Councillor Horner.
For.
Councillor Johnson.
For.
Councillor Mann.
For.
Councillor Monday.
For.
Councillor Mrs Parker.
For.
Councillor Ritchie.
For.
Councillor Mrs Spray.
For.
Councillor Unsworth.
For.
Councillor Wrench.
For.
Thank you, members. That has been approved unanimously. We now come to the final application, which can be found as 5E, application 20-02204 full, 4 Ashes, Blackmore End, Weathersfield, can be found on pages 86 to 94, and we do not have any speakers or presentations on this application. So I go straight to Carol to make a planning presentation for us. Thank you, Carol.
Thank you, Madam Chairman. Good evening, everyone.
Good evening.
So this is a full application. It's a retrospective application for change of use of the site from food warehousing to a data storage archive center. And the site the site address is 4 Ashes in the south of Blackmore End in Weathersfield. And this is the site location plan. As you can see from here, the site is where the red star is located in the southern part of the Blackmore End village. It's accessed from a rural link branch off from Blackmore End Road. This is an existing ground floor plan. The main entrance to the building is from the north elevation from here. On first floor, there's more office and meeting rooms and facilities for staff. Apart from that, most of the internal floor areas are for storage or for filing storage purpose. There's a couple of site photos. This is the main entrance of the application site from access from the rural lane. The existing vehicular gate is manually controlled. This is a slightly zoom out photos. As you can see, this is the rural lane, and this is the agricultural buildings to the west of the application site that belongs to Wafers Farm. This is a picture like taking right in outside of the main entrance of the building. As you can see, there's some dedicated parking areas in front of the main building. Internally, there are some photos showing the storage area. This is the first floor storage area. And there's some office, meeting room, and printing areas just next to the staircase on first floor, fronting onto the north elevation. The eastern portion of the site has been fenced off by a security fence. There's a newly erected additional storage building to the southeast of the main building. However, it's not covered by this current application, and it has been erected without the benefit of planning permission, and is a subject of another application that currently pending consideration. The northeastern part of the site appears to be occupied by a highway construction company, and there's some storage of construction materials. However, the applicant is saying that is not related to the data storage center and it will be removed shortly. In summary, the site is about 1.18 hectare. The main building has a gross floor area of about 2,824 square meters. All previous approvals related to the site dating back to 1970, 1974, 1987 were all subject to approval conditions that specifically restrict the use of the site and the building for potato packaging or food warehousing, and no other BU storage use would be permitted without prior consent from the local planning authority. According to the applicant, the data center has been operated since 2011. Is mainly related to record management and file archive for professional companies. Currently, the data center recruits about 10 full-time staff, and on average, about 2 trips will be generated by the delivery transit vans. In terms of the application, there's no objections or public representation has been received. Under the current policy, policy RLP 38 of the adopted local plan reviews allow for conversions of rural buildings for business or community use subject to criteria. Officers are of the view that the criteria has been fulfilled, and thus therefore, the principal development is considered acceptable. In terms of design and external appearance of the building, it is similar to the adjacent agricultural buildings, especially those within Wafers Farms to the immediate west of the site. As compared to the previous use as a food warehousing, a food warehouse, the current use as a data center generate a lot less traffic. It's not considered that due to the nature of the data center that it will create significant amount of traffic, and sufficient parking has been provided within the site. In view of the separation distance to the nearest residential property, which is about 60 meters away at Wafers Farm, officers is of the view that is unlikely to cause detrimental harm to local amenities. And because the number of employees recruited by the current data center is less than the previous food warehouse use, it's considered that there's no increase in terms of demand for using open space and recreational facilities, and therefore it's not considered that a contribution should be sought at this for this application. And therefore, when we consider about the planning balance, it's recommended that the current application should be granted subject to conditions. Thank you.
Thank you, Carol. Thank you very much indeed. I do not have anyone on the chat function wishing to comment.
I'm happy to kick off, Madam Chair.
I've got Councillor Mrs. Spray now, Councillor Mann, and I'll come to you after that. Councillor Mrs. Spray. Sorry.
Thank you, Chairman. Just very briefly then, I think this is well, perfectly acceptable. It's retrospective and it seems to have been operating for this purpose for some time. The vehicle movements are small, transit vans, fairly small vans, which is obviously extremely preferable to the much larger lorries that might have been using it as a distribution unit. There are no objections from any of the statutory consultees, so I actually, Chairman, see no reason not to move officer's recommendation for approval. Thank you.
Thank you, Councillor Mrs. Spray. Does it find a seconder?
I'll second, Madam Chair.
Thank you. And you wish to speak, Councillor Mann?
Well, I think I agree it's acceptable in design, in appearance, no highs, objection, amenity aspect, okay as well. Welcome the reduction in traffic, but notice the informative to the applicant. I mean, this has been operating for 10 years, and there's another extension gone up without planning permission either. Now, you know, one maybe, but two, that's I think not a healthy position for this organisation to be in, and I hope the situation will be rectified quickly.
Thank you, Councillor Mann. So do I. I do not like retrospective applications. Councillor Mrs. Parker.
Yes, thank you. Yes, I agree with everything that's just been said by Councillor Mrs. Spray and Councillor Mann. It is good that there are the opportunity to reimpose the conditions limiting the use of the premises to the data centre, and also to impose a condition about outdoor storage. I think both those conditions are pretty important. What I don't like with these conversions, and I think it's quite difficult to resist, but is the fact that they generally attract a lot of heavy vehicle traffic with them. So this, I think, is infinitely preferable. But completely agree with Councillor Mann's comments about two unauthorised planning developments. So yes, a good point made. Thank you.
Thank you, Councillor Mrs. Parker. Councillor Unsworth.
Sorry, I am still here. I've just turned the video off. I'm just a little concerned about using the term a data center. In my view, this is document storage. It's not a data center. If this was a data center, I would be asking questions about power supplies, resilience of the place. I'd be asking why we've not had consultations from the police and the security access, because if it was a data center, it would be critical national infrastructure. So is it possible that we can refer to it as document storage and not a data center? Because if we give planning permission for a data center, we are opening, exposing ourselves, I think, there to something that is simply not what it is. Data centers would have diesel generators and backup. They'd have fuel storage on site. This is a world I come from. I'm fully aware. I've delivered several data centers around the world. And I do not think this is a data center, it's document storage. So if we can clarify that position, please.
It's called data storage on the thing, data storage, yeah. and archive center.
If we can make it clear that it is not a data center, I think that would protect us as a council better.
Well, if that's what the applicant is calling it, I don't know that it's up to us to change it. I'm not really sure. I will. Perhaps Chris would like to come in on this one, please.
Thank you, Madam Chairman. I might actually need to confer with Carol over this.
Sorry.
And, if we could just have a quick look at the application form again.
Thank you. Oh, a lot of noise tonight.
Thank you, members, for your patience while officers do confer. Just to remind you that no debate should take part while the officers are just taking some advice. Thank you. Officers, are you able to provide the guidance to members, please?
Apologies, Madam Chairman. Sorry, I just had to check between the application form and the planning statement there quickly as well. Councillor Unsworth, I think, is the concern the specific reference to data centre, because within the planning statement it refers to the main purpose relating to data stroke archive material. So in terms of the storage, so is that the point that you think the description of development should be referenced in that way rather than as a data centre? Have I understood that point correctly?
Yes, it's the storage of electronic data. So these, obviously they have servers running and are massive places generally. So it might be optically character recognized or scanned in. So it's digital representations of documents. So it's document storage and data of document storage, but it is not a data center by any means.
Okay, so if we ask Councillor Unsworth, if you're suggesting that the description of development is amended, so I mean it's currently described as a data storage stroke archive centre. That's the description of development that's been put forward. So it doesn't refer to a data centre at the moment.
Okay, I'll take your guidance on it, but I think we should make it clear that it is not a data center in the electronic sense of a center for managing electronic data, which is connected to the internet and has, credit card data on it, servers, that sort of stuff.
So I understand the point and the concern. I'm not sure with the description of development as referenced within the application submission. The planning statement and the other documents are all in the public domain. I'm not convinced that we would need to, on the basis of data storage and archive, I'm not sure we need to actually amend the description of development in that scenario.
Sorry.
Surely if they've been in there for 11 years and there's no sign of anything electrical like this at the present time, then they are using it. I mean, Carol mentioned it was all filing cabinets and we saw pictures of that. We didn't see any of the kind of thing Councillor Unsworth is describing. And if they've been there 11 years, then surely it would have been there.
It's just a concern that as a data center, it's still an archive, as a digital archive. And I expressed a concern to the committee, so I still think that we should exclude it as a data center per se, as a traditional data center that a bank would use or any of the major services they use. There's quite a regular thing now for companies to build data centers and sell out the cloud space on it or the service space on it.
So, Councillor Unsworth, sorry, I do understand the point that you're making in terms of those facilities being a potential target. The description, though, here is for data storage.
Chairman, I'm ever so sorry. We looked like we've
referred to a data centre, data storage stroke. I'm sure we can amend the description of development to remove that particular word, but it doesn't.
Chris, we're losing you, unfortunately. I think the gremlins are getting in the system this evening. I mean, as far the application actually says data storage archive center. It doesn't say data center. So I don't know whether we change it or not.
Chairman, if it says data can cover everything from manual data through to electronic data as described by Councillor Unsworth.
Yeah.
If I just draw the parallel to the Data Protection Act, that covers all data that is produced in filed form or in digital data as described by Councillor Unsworth. The description has been provided to Data Storage and Archive Centre. Unless the planning officers can provide us any legal reason as to why that needs to be altered, then I think the point needs to be moved on from. Thank you.
Thank you.
We do have Councillor Cunningham.
Yes. Well, I've also got something, Chairman, I need to give advice on previous applications, so I'm getting more and more confused.
Yes, apologies, Chairman. That's a matter I need to attend to on the conclusion of this item.
Okay, thank you. Thank you. Councillor Cunningham.
Thank you, Madam Chairman. I was just going to suggest we move the conversation on, but the advice from Mrs. Wisby has been to do that. So nothing else further to add. Thank you.
Right, thank you. Well, I think I can't even, I've got so confused now. I don't know if it's been moved and seconded or not. Yes, it has, hasn't it? Yes,
Yes, I
moved by,
moved.
yes, moved by Councillor Mrs. Spray, seconded by Councillor Mann. I'm going to put that to the vote at this stage now. So Councillor Abbott.
For.
Councillor Bowers.
For.
Councillor Cunningham.
For.
Councillor Horner.
For.
Councillor Johnson.
For.
Councillor Mann.
For.
Councillor Monday.
For.
Councillor Mrs. Parker.
For.
Councillor Ritchie.
For.
Councillor Mrs. Spray.
For.
Councillor Unsworth.
Abstain.
Councillor Wrench.
For.
Thank you, members. That application has been granted. And that brings us to the end of our planning items. But I think Emma wants to give some advice on a previous application before I close the meeting.
Thank you, Chairman. Chairman, at this stage, I would invite you not to terminate the meeting at this point and to ask that we reconsider the Turlin application. Regrettably, our YouTube broadcast ceased at that point of our application. Now, in order for this meeting to be compliant to meet all the regulations, we need to have the members in attendance in a forum, which is the Zoom meeting, and then a public ability, which is the YouTube channel. It appears regrettably beyond our control that the YouTube channel ceased at the beginning at the Turlin item. That does mean that we could have a legal challenge to that part of the meeting and that decision of this committee, which is most regrettable. I appreciate that we've gone through 10 months of holding these meetings, and this is the first time this has happened. To ensure that we do have a safe decision in terms of the planning, this planning decision, I'd invite the officers to set out the presentation to members and invite members to have a brief summary of their previous debate and to take the vote so we have a clear record of the decision as a public participation in the planning committee. I know this is very unusual and this is the first time this has happened, but this is, I think, is the safest route for this authority to do, is to retake that item, and I am grateful for members' understanding on this particular matter. So I would be grateful if the officers could recommence that presentation. The public question time letters are already in the public domain. They are published on their website. Members have had sight of those, and members did hear substantive parts of those. So I don't feel it's necessary for those questions to be, those statements to be read out again at this time. So if I can invite the officer to remake the presentation for members and then to take it forward again. But I do apologise as Chairman. I do think this is the safest route in the circumstances. Thank you.
For safety's sake, for the time, as the time is progressing, can I get someone to move standing orders so that we don't have to, thank you. Does it
do that for you, given the time?
Does it find a seconder?
Yes, Chairman, I'll second.
Thank you. I will take silence as your approval that we're moving standing orders to extend the meeting should we be so required, but I hope we won't be required to do so. Lisa, I will come back to you for a presentation again. Sorry. Thank you.
Thank you. This is a full application for the demolition of the existing detached dwelling house and the erection of a replacement 2 to 3 storey detached dwelling house at Rosemead, Fairstead Road in Turling. This is the location plan. The site is located within the defined village envelope of Turling. The property is set between neighbouring detached dwellings to the north and to the south. To the west is the residential curtilage with a number of outbuildings. To the east is Fairstead Road itself and agricultural farmland beyond. The site lies outside of the conservation area. Turning to the existing site plan, you've got the existing dwellings located here. To the northern boundary is a detached double garage, and to the south is an annex building. Here is some elevations of the existing front and rear elevation. So 2-storey dwelling, render and brick, and the flank elevations of the existing dwelling. So looking at the proposed site plan, you can see where the proposed replacement dwelling is to be in grey. The blue is the existing footprint of the dwelling, and the red shows the footprint of the extant permission for extensions and alterations. You can see that it would be sort of very much on a similar footprint there. The access to the site remains as per it is as existing, and no changes made to that. So driveway provision for parking, and this frontage hedge is also to be retained. I should also say at this point that this double garage and the annex building would also be retained on site and are unaffected by the replacement dwelling proposal. So looking at the ground floor plan here, this is where the family living accommodation would be. The first floor plan shows 3 bedrooms with en suites and additional provision here for a carer's suite or carer's bedroom if required. The accommodation in the roof space or in the second floor plan is a further bedroom with en suites and a treatment room here. So looking at the front elevation here, this is the view from Fairstead Road. You can see that the dwelling would be 2-storey with accommodation in the roof space provided by these 3 dormer windows. It's designed with a Georgian vernacular, front canopy and columns. And this red dashed line indicates the size of the dwelling that would be created by the extensions and alterations. So it's slightly lower in height with the removal of the chimneys. Just quickly here, a front elevation comparison. So on the left-hand side is the replacement dwelling that's sought within this application. And on the right-hand side is the extant proposal, so the dwelling that would have been created by the extensions and alterations. Looking here is a rear elevation of the replacement dwelling, and the north flank elevation and the south flank elevation. So just some photographs here. Here's this taken from Fairstead Road, so you can see the existing access that is unaffected, and this hedgerow that would be retained. You've got the 2-storey dwelling here, which would be demolished, the detached garage building here that would be retained. And another view just from here from Fairstead Road, so standing sort of towards the access, you've got the 2-storey dwelling to be demolished and the annex building that will be retained. So a quick update to members in terms of one particular point for conditions, and that's condition 3 relating to levels. So since the agenda has been published, we have now received a full proposed levels plan that is acceptable. So officers are seeking to change condition 3 to be a compliance condition and to add that plan number there, revision A, as an approved plan. Just coming back really quickly on some points that the Parish Council made, that's in regards to initially their floor area calculations, and that's something that members will note that officers didn't do that calculation, and that's because the principle of the replacement dwelling within this village envelope is accepted. The officer report also does not detail policy RLP 22, which relates to accessible housing and lifetime housing, which talks about new dwellings being required to be capable of adaptation to meet the needs for disabled people. So in this instance, the dwelling has specifically been designed to meet the needs of the family, and officers do not consider that there's any conflict with the policy. The Parish Council also draw attention to some of the preamble wording in regard to needs for external play areas. However, officers don't consider will consider that it's not applicable because that preamble and policy relates to special needs housing falling outside classes C1 and C3, whereas this proposed replacement dwelling quite clearly remains within C3 use as a single dwelling house. And just two points really on conditions, picking up on initially the landscape point made. So earlier planning applications did have a condition regarding tree and hedge protection. Now the application before us isn't seeking to remove any of the established landscaping, which mainly lies within the rear garden and that frontage hedge, and we didn't feel it was necessary to impose such a condition. However, officers are content that a condition regarding hedge and tree protection and retention could be imposed if members were minded. And equally, members will note that officers have not imposed a condition for lighting as requested by the parish, and that's because given the scale and the nature of the application, we don't feel that would be reasonable or meet the tests for a condition. So in terms of the planning balance and the planning conclusion, the replacement The principle of the replacement dwelling within the village settlement is acceptable. It's a similar siting to the existing dwelling and will retain an appropriate relationship with boundaries, neighbours and the wider street scene. The size and design follows the extent approval for extensions and alterations and would remain acceptable in size, scale and design. The overall development will result in a high quality accommodation and amenity for future occupiers and would not result in any adverse impact to neighbours' amenity. Access and parking provision are acceptable, and therefore officers recommend to members that planning permission be granted, subject to that change to condition 3 relating to a compliance for levels. Thank you.
Thank you very much, Lisa. Thank you very much indeed. I'm going to go straight to Councillor Mrs. Spray.
Thank you, Madam Chairman. Thank you, Lisa. I moved approval for this first time around and will do so again. My only comments were that I think the design is good. There is plenty of room on the site for this. The footprint is the same or similar. And although provision has been made for accommodation for a carer, this is very much destined to be a family home. And I was happy to move officer's recommendation for approval. Thank you, Chairman.
Thank you, Mrs. Spray, and that does that includes the condition change of the conditions 3 on the levels, change it to compliance. Yes.
Yes, thank you, Chairman.
Thank you very much. Does it find a seconder before I move on?
Seconded, Madam Chairman.
Thank you, Councillor Cunningham. And do you wish to speak?
Yes, just to add to the comments made by Councillor Mrs. Spray. As a former councillor for the Turling area, I know the site well, and I also know that Turling and Fairsted Parish Council are very proactive in their representations on planning matters, and I hope that the explanations given by the officer in the presentation will allay some of those concerns. So happy to second. Thank you.
Thank you, Councillor Cunningham. Councillor Cunningham, I do believe the first time round you wanted an informative regarding...
Madam Chairman, my apologies. We did, absolutely. Regarding the protection of the hedge and trees, wasn't it? It was a protecting informative, wasn't it?
An informative to protect the trees and especially the hedge during construction of the new building, I think is what you required.
Absolutely, that was it. Yeah, indeed
yes,
it was.
I must admit we're all getting a little tired. Councillor Abbott.
Thank you, Madam Chairman. I'm going to have to agree with Councillor Cunningham for the second time this evening, so it's becoming a habit. But yes, the Parish Council has a very proactive role in planning applications. They're to be commended for that. And I do take on board the point they've made about this area being subject to many applications in recent years all along that section of Fairsted Road and indeed New Road. But in this instance, I think this is an acceptable proposal, not least because of the fallback position which officers have set out so well, that they do have the ability in the extant permission to build something quite similar. And given that there are no other impacts, I think that really, amounts to the fact that we will have to give planning approval for this, notwithstanding and noting the Parish Council's concerns about the development pressure on the area. Thank you, Madam Chairman.
Thank you, Councillor Abbott. I have no one else wishing to speak this evening. Well, it has been moved and seconded by Councillor Mrs. Spray. Moved by Councillor Mrs. Spray, seconded by Councillor Cunningham, that we approve this with the change to condition 3 to a compliance and an informative to protect the hedge and trees during construction. And I'm going to now put that to the vote. Councillor Abbott.
For.
Councillor Bowers.
For.
Councillor Cunningham.
For.
Councillor Horner.
For.
Councillor Johnson.
For.
Councillor Mann.
For.
Councillor Monday.
For.
Councillor Mrs. Parker.
For.
Councillor Ritchie.
For.
Councillor Mrs. Spray.
For.
Councillor Answorth.
For.
And Councillor Wrench.
For.
Thank you, members. That application has been granted unanimously. And that now brings us to the end of our planning meeting, and I will close the meeting at 3 minutes to 10. I would also very much like to thank all our officers for this evening and the members of the public watching on YouTube, and especially those people that made a presentation, and especially those that did the presentation themselves, and Emma, the facilitator. And I'd like to thank Lisa for doing the presentation for a second time. I very much appreciated that you did that for us, and I do hope that now we have met all the legal requirements for this planning meeting and that we don't have to do any of them again. Thank you very much and good night. And I hand over to Emma to close the meeting. Thank you.
Thank you, members. Before I ask the webcasting officer to terminate the broadcast on the YouTube channel, just to remind members that we will be retaining performance data to your connection to this meeting this evening. This is just in case we have a legal challenge to the way we've held this meeting. I will now ask the webcasting officer to terminate the broadcast on the Council's YouTube channel.